No, not right now, Mr. Rife. All right, Mr. Schmidt, are you ready?
Yes, I am.
All right. Who are you ready on, sir?
Shannon Roseman.
All right, this is cause number CR 2363, State versus. Is it Rosman Shannon or is it Shannon Rosman?
Rosman Shannon.
Rosman Shannon. Okay. All right. I show that we're set on motion to revoke. Mr. Schmidt, go ahead.
Judge, I was just recently appointed to represent Mr.
Shannon.
And we briefly met yesterday. We were negotiating with the state, asked that it be reset for March study.
You said March 7th. All right, court will set Mr. Shannon for hearing on motion to revoke on March 7th. That'll be at 1:30.
Yes, sir. Thank you. Yeah. Yeah, come on down.
Are you ready on Mr. Young as well?
Yes, sir.
All right, I think Ms. Taberham went to get my paperwork. This is cause number CR 22402, State versus Floyd Franklin Young. Mr. Young, if you will raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
All right, thank you, sir. You can lower your hand. All right, just speak up loudly and clearly for me so I can hear you and so my court reporter can take down everything you have to say, okay?
Yes, sir.
All right, Mr. Young, your name is Floyd Franklin Young, is that correct?
Yes, sir.
And Mr. Young, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
Yes, sir.
Can you tell me about that?
Bipolar, schizophrenia, and a couple others, sir, that I can't remember off the top of my head.
Are you currently on medication or undergoing treatment for those?
Yes, sir.
Okay.
I'm on medication.
Do you feel like you have a rational understanding of what's going on around you today, especially in this proceeding?
Yes, sir.
All right. In this case, you're represented by your attorney, Mr. Schmidt. Are you pleased with Mr. Schmidt's representation of you?
Yes, sir, I am.
Do you feel like you've had enough time to talk with him about your case and have all your legal questions answered?
Yes, sir, I do.
And Mr. Young, is there anything about this paperwork today that you've read and signed that you do not understand?
No, sir, I understand it fully.
Thanks, sir. Mr. Schmidt, do you believe Mr. Young to be competent today?
I do.
And you've explained to him his rights as they pertain to this case and this plea agreement?
Yes, I am.
And you believe that he understands all of his rights and he's entering into this plea agreement intentionally, knowingly, and voluntarily?
I do.
All right. All right, Mr. Young, you are charged with the first-degree felony offense of murder, which carries a range of punishment of not less than 5 years or more than 99 years or life confinement in the Texas Department of Criminal Justice Institutional Division, and also a fine not to exceed up to $10,000. Do you understand that range of punishment?
Yes, sir, I do.
I see that the proposed plea agreement in your case is that you would plead guilty to that offense in exchange for the state's recommendation that your punishment be assessed at 35 years confinement in the Texas Department of Criminal Justice, a $1,000 fine plus court costs, reimbursement fees, and the DA's office would be asking the court to dismiss an evading arrest or detention that they have not filed. Is that your understanding of the plea agreement?
Yes, sir, it is.
And that's what you're asking the court to approve today?
Yes, sir, I am.
All right, then, understanding the range of punishment, understanding the plea agreement, Mr. Young, how do you plead to murder?
Guilty, sir.
Are you pleading guilty to this crime because you are guilty of committing this crime and for no other reason?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty to this offense?
No, sir, they haven't.
All right, the court will accept the defendant's plea of guilt. Mr. Schmidt, any objection to the state's evidence supporting the plea? All right, state's evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Yes, Your Honor. In regards to victim notification, the victim's mother was made aware of the plea agreement today. It is my understanding that she is watching via YouTube. She was not able to complete the victim impact statement for the court's review. She's going to return that to our office and we're going to forward it to TDCJ. But we do not have it for the court at this time. However, she is watching today, like I said, via YouTube.
And is she supportive of the plea, Ms. Heisel, do you know?
Your Honor, I think given the situation, understandably, no amount of punishment will ever make things right for her. But she does understand what the plea agreement is in this case.
Thank you, Ms. Heisel. Mr. Schmidt, anything else on behalf of your client?
No, Judge.
Okay. All right, the court's going to review the evidence. All right, the court has reviewed the evidence and the court finds sufficient evidence to convict this defendant. Court will follow the plea agreement between the state and the defense. Court hereby convicts Lloyd Franklin Young of murder, assesses his punishment at 35 years confinement in the Texas Department of Criminal Justice Institutional Division, orders him to pay a $1,000 fine, $290 court cost, $20 reimbursement fees. The court dismisses DA 2022-1335, evading arrest or detention. And the court awards Mr. Young 106 days credit towards his sentence for the time that he has spent in jail on this cause. Mr. Young, you hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. I'll have you step over to Deputy Everett to take a fingerprint.
Yes, sir.
Is that all you have, Mr. Schmidt?
Sir.
Thanks, sir. we have any other counsel in the jail that's ready?
Judge, we have no counsel present.
Okay. All right. Mr. Lowe is coming out there. He has a writ with Mr. Daniel West. So he's on his way. He was here. I've asked him to come out there so he can speak with Mr. West. And then Mr. Hawkins is here. Mr. Ashmore, I'm not sure where Mr. Ashmore is. I think he was in trial in Rockwall. I'm not sure if he's going to appear via Zoom or if he's going to be in person. And let's see, I have Mark Trainer appearing via Zoom. Like I said, Mr. Hawkins is here. And it says that Mr. Weiner is going to appear via Zoom. So,
I have everybody ready in the courtroom. I'm just waiting for attorneys.
okay, thank you, sir. On Dusty Roads, I've got a note. You said release to TDC per Henderson County. I thought we had already resolved Mr. Rhodes.
We were supposed to Zoom him today from what I have wrote down. And then when I looked him up, it shows on Henderson County's website that he was released to TDC. Justin did not know that, I don't guess, because he asked me about him appearing. Justin had a plea in Henderson County at 1:30. He said it wouldn't be long.
Okay. Maybe my recollection is just not right.
And then well, it always is.
No, it's not.
And then the other guy was in federal custody and I thought we were dismissing it.
We,
Trainer.
for the court's information on Mr. Trainer, we're waiting. Mr. Butler is supposed to be taking federal.
Here, hold on, Tyler. Let me bring in Mr. Trainer so he'll be present for this conversation.
Can you hear me, Your Honor?
Yes, I can hear you, Mr. Trainer. How are you?
Oh, I'm doing well. How are you doing?
Doing fine, doing fine. All right, this is cause number CR 2262, State versus Corey James Butler. Mr. Woodwalk, I think you were about to give the court an update on Mr. Butler.
Judge, we are aware that Mr. Butler is in federal custody. We believe he is about to take a plea agreement with the federal authorities, but we don't know what that is. Once he has taken whatever deal that he is going to take with the federal government, the state is going to dismiss. We're just waiting for that to happen.
Do we have a timeline on when that federal plea is going to occur?
Your Honor, he sent me over a copy of his of the deal that he got, and I actually just sent it over to the DA's assistant here today. But it's a sealed plea agreement, and so I'm not really sure why it's sealed or if it's something that I need to hold back on. I sent them just the cover page and the signature page where he and his attorney had signed off on it, but your attorney over there is correct. They have not gone ahead and the judge hasn't signed the deal yet, but it is a foregone conclusion that he is signing this deal and is pleading to it there in federal court.
Okay. Well, I guess let's just set it for 60 days and let's see if it's done in 2 months. So let's look in April. Are you available on Tuesday, April 25th, Mr. Trainer?
Actually, I believe I just set the trial for that date. Hang on a second. Oh, but let's see, April 25th, Your Honor.
Yes, sir.
All right, Thursday. And that will still be in the afternoon at 1 o'clock or 1:30.
Yes, I call all my inmate cases at 1:30.
All right, yeah, that'd be fine, Your Honor.
All right, so Tuesday, April 25th, 1:30.
Uh-huh.
All right, we'll set it for a status. And Mr. Woodwalker, I'm sorry, I don't recall what you said. You said once he takes that plea, what is your intention?
Judge, once he has actually resolved his federal business, which we believe will result in incarceration, we will dismiss our case. So if we get information prior to that he has resolved his federal business with a plea that results in some sort of incarceration, we will just dismiss, and I'll let Mr. Trainer know, and then obviously he won't have to make another appearance in this case.
Okay, so Mr. Trainer, just plan on appearing via Zoom that day as well.
Okay, I appreciate it.
All
Your
right.
Honor.
All right,
All
thank
right,
you,
thank you
Mr. Trainer.
much.
Appreciate
All
it.
right. Bye now.
All right, Mr. Hawkins, are you ready with Mr. Rife? All right, this is cause number CR 21-308, CR 21-307, State versus James Clifton Rife. All right, so you're going to have to bring me up to speed. So my last recollection is that Mr. Rife was going to plead to incarceration time at TDC, and I believe I reset the case to allow him time to take care of some business before he went in. And then Mr. Rife did not appear at court, and then we put a warrant out for Mr. Rife, and now he's here to plead to probation. So someone's going to have to bring me up to speed on that.
Sure. I can't remember the reason why Mr. Rock this thing on that. Continue work, Mr. Woodward on this case. And we were able to secure further negotiating, and we ended up working on a different deal. It wasn't, it didn't have anything to do with not appearing last time. I don't remember the reason. So it's worked out. Continue to work on the deal. Trying to resolve.
My only concern is that if I approve this deal, then I'm counting on him showing up to probation every month that he's supposed to show up. And if he won't show up for me, why would I think he's going to show up for them?
He has prior probation cases. He's either one of them. Can't say I'm satisfactory, but I know enough to where it's discharged or satisfactory. That's fine. Showed up all the time. I don't know that information. I know prior probations have been successfully discharged. In this case, in this case here, on more settings than not, I don't really being done on. I know Mr. Rock might have been late a time or two, but I know the time who's here to save that setting that we did this. Really consistent. We do have a $700 fine assessment state. I do have to check here.
State, is it my understanding that you had gotten warrants or indicted Mr. Rife on failure to appear or bail jumping? Is that right or wrong?
Judge, we have not indicted it. I explained to Mr. Hawkins, who was in communication with his client, that if he did not resolve this case very quickly, I was going to. But again, it's been less than a month since he has failed to appear. I have not indicted him for bail jumping now.
All right, Mr. Rife, you're telling me as you stand there, and I've not put you under oath yet. Okay, I haven't put you under oath. I'm just going to ask you point blank, if I put you on probation, are you going to no-show them like you no-showed me?
No, I will call. I will talk to them as I can. I'll call them anytime I'm supposed to, and make a date. I will do it when I'm supposed to. That day I couldn't come.
And why couldn't you come that day?
Well, I had started trying to talk to my attorney on that day after Christmas, December 26th. I started trying to get a hold of my attorney to get him to come in and stand here, or us be here to redirect it one time or something like that. And I didn't get a hold of him, but didn't get no response back until the day I was supposed to come in. And he sent me back a text saying that in 1 hour we'll be able to talk to you. And 1 hour never came, and he showed up in court, and then I knew I was supposed to be here. I didn't know if I was supposed to be here at 9 or 1:30 in the morning. But I knew I was supposed to be in here sometime on January 3rd to time for my time. And it wasn't the right time. It just wasn't the right time. I don't mind the time was my time. I didn't mind coming in and doing it. It just wasn't the right time. I had dinner work going on I had land closures still going on for land deals and stuff that I was still trying to close up. It just wasn't the right time, you know?
So what's gonna happen if I approve this and I put you on probation and they say, James, you need to be here on April 15th to check in for probation? Are you gonna call them up and say, you know what, today's not the right time for me?
I would not do that. I'm not doing that because I don't do that with certain. Probation is not incarcerated. It's not taking me away from my things that I need to accomplish on the outside world. It's not taking me away from everything that I have. It's not gonna make me lose everything that I've got. Where incarceration at that time wasn't, and my ducks weren't all in a row and they weren't swimming straight. And now they are.
Well, you know, I love your analogy, ducks in a row and swimming straight, because when I put my ducks on probation, I expect them to be all in a row and swimming straight down the lane or straight down the river of compliance and doing what they're supposed to be doing. You're telling me that if I honor this agreement between you and the state, that you're gonna fly straight, swim straight, whatever. You're gonna do everything that you're supposed to do. And now these probation officers aren't gonna be calling me up, telling me, you know what, James ain't coming in. He does what he wants to do. That's not gonna be you.
Never had that on probation.
All right. All right, raise your right hand. I'm gonna place you under oath. Other hand. Do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, you put your hand down. Your name is James Clifton Rife, is that correct?
Yes, Your Honor.
And Mr. Rife, are you a United States citizen who reads, writes, and speaks English?
Yes, Your Honor.
Have you ever been diagnosed with a mental condition?
After that,
In this case, you're represented by your attorney, Mr. Hawkins. Are you pleased with him as your attorney?
yes, Your Honor.
Do you feel like you've had enough time to talk with him about your case and had all your legal questions answered?
Yes, Your Honor.
Is there anything about this paperwork that you've read and signed today, Mr. Rife, that you do not understand?
I don't think so.
You understand everything that you
I
signed?
think so.
Do you have any questions that Mr. Hawkins has not been able to answer for you? Mr. Hawkins, do you believe Mr. Rife to be competent today?
I think, Your Honor, I think I'm discussing paperwork, terms, conditions, everything covered today. Like we understood everything that we discussed. And my dealings with,
And you've also explained to him his rights as they pertain to this case. And do you believe that he understands those rights and he's entering into this plea agreement intentionally, knowingly, and voluntarily? All right, Mr. Rife, you are charged by indictment with a third-degree felony offense of possession of a controlled substance and penalty group 1 greater than or equal to 1 gram less than 4 grams. That is a third-degree felony offense. A third-degree felony carries a range of punishment. If you were to be convicted and sentenced, it could not be for less than 2 years or more than 10 years, and you could not receive a fine of more than $10,000. Do you understand that range of punishment?
Yes, Your Honor.
I see the plea agreement in this case is that you would plead guilty to the state's allegations against you. And in response to that, the state would urge the court to convict you, sentence you to 10 years in prison, but they would be recommending that I suspend that sentence today, place you on probation for 10 years, order you to pay a $7,500 fine, $180 restitution, plus your court costs and your reimbursement fees. And the state has indicated they will dismiss several unfiled charges. Is that your understanding of the plea agreement?
Yes, Your Honor.
And Mr. Rife, that's what you want the court to do today?
Yes, Your Honor.
All right, then, Mr. Rife, how do you plead to possession of controlled substance in penalty group 1 greater than or equal to 1 gram, but less than 4 grams?
Guilty.
Are you pleading guilty to this crime because you are guilty of committing this crime?
Yes, Your Honor.
Has anyone threatened, forced, or pressured you to plead guilty? Court will accept a defendant's plea of guilt. Mr. Hawkins, any objection to the state's evidence supporting the plea?
no objection.
State's evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
I apologize.
Hang on just 1 second. Anything further?
No,
from
Your
the
Honor,
state?
we would rest and close at this time.
All right, anything further from the defense, Mr. Hawkins? Does Mr. Rife want to say anything?
I apologize for this report day on January 3rd.
Well, I appreciate that. It's more important that you don't miss any of your probation meetings or any other court hearings from here on out.
I will always call ahead of time. I will always make different preparations that I have.
You can thank Mr. Hawkins for continuing to work on your behalf to get you this deal, and Mr. Woodwhite for extending it to you, okay? All right, if there's nothing further, then the court's going to review the evidence. All right, the court has reviewed the evidence and the court finds sufficient evidence to convict the defendant. Court will follow the plea agreement reached between the state and the defense. Court hereby convicts James Clifton Rife of possession of controlled substance, third-degree felony, 1 grams to 4 grams. Court assesses his punishment at 10 years confinement in the Texas Department of Criminal Justice. Court will suspend that sentence today, place him on 10 years community supervision, orders him to pay $7,500 fine, $180 restitution, $290 court cost, $85 reimbursement fees. And Mr. Hawkins, you're retained, correct? Court also dismisses under section 1245 CR 21-307, DA 2021-0780, possession of controlled substance, and DA 2021-0781, possession of marijuana less than 2 ounces. Oh, great.
Judge, with the completion of the plea, I believe somewhere over there are the withdrawal of the 2 failure to appear warrants, so Mr. Rife doesn't get picked up on those warrants after he's resolved his case. If not, let me know, and we'll make sure that they are turned over to you as soon as possible.
Yes, I believe that Ms. Taberham brought those to me.
Was that what she just handed you? That just reminded me.
No, that was the conditions of probation, but she gave them to me previously.
Perfect, thank you.
Ms. Taberham? Is Patty over there? Okay. We're gonna need somebody to fingerprint him. I don't know if you can get one of the deputies outside. All right, Mr. Rife, you're hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. In just a moment, a bailiff's going to come in here and they're going to take your fingerprint. They're going to put it on this document. After that, Ms. Mewburn here with the probation department, she can give you more information, okay? Let me give these to you. You're welcome.
Thank you, Your Honor.
You're welcome. Go ahead and step out there. They may fingerprint you out there. I'm not sure what they're going to do. All right, you're Mr. Bowie, correct? Okay. All right, I'm going to slide over here so you can see me. All right, this is cause number CR 16-232, State versus Ernest Jerome Bowie. Mr. Bowie, I believe that there's a motion to revoke that's been filed in your case. You're on probation, correct? Okay, so there's been a motion to revoke filed. And so there's a warrant for your arrest right now too. Okay, and we're gonna talk about that in just a moment. What's your intention on an attorney? Are you gonna hire an attorney to represent you on the motion? With me. Yeah, go ahead and get that. You get your, here, let me have that. I'll fill that out. Go ahead and do your order and then I'll call back up. in a second. Give a pen. How about that pen there? I'll give her out of that. It's just, these won't work with them. Mr. Bowie, you've already been arrested on this warrant, haven't you, and posted bond? Okay, yeah, you did that on January 11th, right? Okay. Yeah, Mr. Bowie's already been arrested on this and he posted bond $25,000 with Roy Brockaway on January 11th.
And he had Brian. Not Richard.
Oh, no, here, let me get.
You throwing things at her.
Yes, I was throwing at her. Just checking her mobility. We're gonna reset this to.
Mhm.
Second slide right there. Mr. Bowie, the court is going to appoint Richard Schmidt as your attorney. Court's going to find you indigent at this time and appoint Mr. Richard Schmidt. That's not the same attorney that you had last time. You had Brian Schmidt last time. He's out of Athens. Mr. Richard Schmidt is out of Canton. Okay, so Ms. Taberham is going to give you a form that's going to have all of his contact information. We're going to reset your case for hearing on March 28th. Okay, and then we're going to send this appointment to Mr. Schmidt so he'll know who you are. So in a couple of days, give him a call. It might take a day or two before he's aware that you've been appointed to him, or he's been appointed to you, and give him time to get more information about your motion to revoke. Okay, so sign that notice of setting right there. That's going to have your date. We're going to give you a copy of that, and then Ms. Taberham's going to bring you a copy of information from Mr. Schmidt. Okay. And so I want you to know you're still on probation. Okay. That means you still got to report, still got to show up. You got to do all these things. Okay. Just because they filed a motion to revoke doesn't mean that you're no longer required to be on probation. Okay. So you need to continue doing those things. Okay. So if y'all want to, y'all can go ahead, step out in the hallway, and then she'll bring that information to you. Okay. All right, I'm gonna bring Mr. Weiner in on Mr. Rhodes. Well, he was there. Let's see. He's not there anymore. Mr. Woodwhite, do you have any more information on Dusty Rhodes? Any more than what Ms. Taberham said that per Henderson County, he was released to TDC?
I do not know anything more than Ms. Taberham regarding his custody. In the past, I've had some discussions with Mr. Weiner about resolving his cases, but nothing recently. And I am unaware about his custody status.
Okay. Mr. Weiner was here a moment ago. I saw him pop in, but now he's not here. So if he pops back in, I'll bring him in. All right, is Mr. Lowe over there? I think I see him in the corner. Hey, Mr. Lowe, are you ready on your writ?
Where do you want the instance here? Oh, that's okay.
All right, this is WR 23-9. This is Daniel West versus State of Texas, writ seeking just bail reduction, or is it probable cause, Mr. Lowe?
Awesome bail reduction are.
Okay. All right. Are you going to call your client today for the purposes of limited purposes of this hearing?
Yes, Your Honor.
All right, Mr. West, if you will, sir, raise your right hand. I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
All right, thank you. You can lower your hand. Make sure you speak up loudly and clearly so that I can hear you on this side, and so my court reporter can take down what you have to say, okay?
Yes, sir.
All right, go ahead, Mr. Lowe.
Thank you, Your Honor. Section name, please. Daniel West. And Mr. West, are you presently incarcerated in the Defendant County Jail?
Yes, sir.
And have you been there since January the 6th?
Yes, sir.
And at present, you have 3 cases cases, with appearance bonds that you're not able to post, is that correct?
Yes, sir.
One for criminal mischief of 5,000, one for criminal trespass for 5,000, another bond for 25,000. Is that correct?
Yes, sir.
And you have no means to make a bond.
I can't afford.
Do you have any family members who can make a bond for you?
No, sir.
All right, so we visited about your situation. Have you received a diagnosis for mental illness?
Oh, yes, sir.
And what's that diagnosis?
Bipolar and depression.
All right, and are you taking medication for that?
Yes, sir.
All right, so you've been incarcerated since January 6th. And you've received your medication here at the jail.
Yes, sir.
And over that month and a half or so, has your condition improved where you understand what's going on?
Yes, sir.
Now, when the first time I met you, we barely could communicate.
Yes, sir.
You were telling me all kinds of fanciful stuff that
Yes,
happened in your life.
Yes, sir.
So with the aid of this medication, now you understand what's going on.
Yes, sir.
Now, you're also dealing with a drug problem. What's your drug of choice?
Marijuana.
Marijuana. Use methamphetamine too.
I have used methamphetamine also.
All right, and so today, if the court were to find probable cause that there's an offense that's been committed, are you asking the court to set a bond, a personal bond, so that you get to receive some drug treatment?
Yes, sir.
And have you located a place that would take you?
Yes, sir. I gave them your number and they did a screening to qualify for it. But I had to, if not that, there's a place in Alba that I can go to. It's a shelter and they help build structure and stuff like that.
And sir, I'm sorry, Mr. West, I need you to repeat about the drug rehab. Once you turn and face Mr. Lowe, it's very hard for us to hear you.
It's Christian invitation place in Wheeler, and I've done called and did a screening to qualify for it first. But if that doesn't work, there's a place over in Alba. It's called Second Chance Ministry, and they also help with rehabilitation. But I do have a drug problem and everything, but I have been trying to work on that myself, you know.
All right, thank you. Go ahead, Mr. Lowe. Sorry to interrupt.
And so if we look back at your life and criminal history, you do have some criminal history in the past.
Yes, sir.
Is that related either to your mental illness or to your drug problem? Or a combination of both?
My drug problem.
And your mental illness?
Well, my mental illness, most of the time I end up going to a Turtle State Hospital when I have a problem. Even the law, when they see me, they'll call and take me to the hospital if I have a problem. But I don't really lately. I've been having medication. I just had to get the medication switched. They got me on different medication now that's working, and that's pretty much.
So how many times have you been to Terrell?
I've been to Terrell quite a few times. I can't count them, but I've been to Terrell quite a few times. I've also put myself in Terrell State Hospital myself to get the medications right.
All right, that's all I have your pass with.
State.
Judge, state would, at this point, state would agree to reduce the criminal trespass and criminal mischief bonds. Both of those are misdemeanors. They're past their time for release due to delay. And then I have just a few brief questions for Mr. West, specifically regarding the third charge, which is a burglary of a habitation charge.
Yeah, go ahead, Mr. Woodward.
Mr. West, where do you live, sir?
Sir, currently I'm staying at the shelter in Alba, Second Chance Ministry, trying to get my life back together. But right now, that's the only place I have. But I use my mother, even though I'm not allowed there. I use her for my mail, all my mail and everything. But that's the post office, and every now and then we see each other. She gives me my mail, or I give her a contact number, and she contacts me to get that mail.
Okay. Have you been accepted to this rehab facility, or are you just in the process? I didn't quite understand.
I've already been in the process to the screening of one, but the other one in Alba, they'll accept you. They'll come and pick you up and everything to get, like if I call them up in Alba, they'll come pick me up. It's they have they work. It's a working facility too. They put you to work and everything like that. And it's based off of Wood County though. But this one that I called recently is right here in Ben Wheeler, Victory Life. That's what it's called, and they got to be screened before you get accepted. I haven't heard anything because I haven't been able to call. Calling back yet. That should be able to get an answer next time I call back.
Okay. Judge, I have no further questions.
All right, anything further, Mr. Lowe?
Not on the issue of bond reduction. I have not been furnished any sort of offense report in this case yet. I'm thinking though there may be an argument whether or not this is a burglary or a criminal trespass. So at this point in time, since the state had established probable cause, we've moved the court to authorize his release on reduced bond with the requirement that that he should report every week to the bail bonds, to the bail supervisor. And if he hasn't gotten it to a place by the end of next week, that a warrant could be issued for his arrest to bring him back here. Because I don't want him, I don't think it's good for him just to be out without any place to go. I think he'd agree with me.
Yes, sir.
All right, thank you, Mr. Lowe. Mr. Woodwhack, anything else from the state?
Judge, just I would note for the record that Mr. West that has been arraigned. There are PC affidavits if the court would like. I'd be happy to submit them. But I heard that Mr. Lowe said it was just a bond reduction and not a probable cause hearing. I can submit a probable cause affidavit. I'm sending to Mr. Lowe the probable cause affidavit through our online portal right now. We have not yet received these cases. It looks like we have received them, but they're not scanned in. But I do have affidavits of probable cause that I will send to Mr. Lowe. And as soon as we do receive the case and get that processed, I'll send those to him as well. But we would ask that the bond be held, the bond on the burglary be held as is, which I believe is set at, I believe $20,000, $25,000. We'd ask that be held as is.
All right, thank you, Mr. Woodwhack. All right, the court's going to take the arguments and the testimony under advisement, and I'll issue a ruling at the conclusion of the docket today and make sure that counsel gets an email of the court's decision.
Thank you, Your Honor.
And I'll tell you, I'm going to consider the 25,000. The state has agreed and indicated to the court that Mr. West is being held on the misdemeanor charges greater than 15 days and has indicated that he would be entitled to personal bonds in those two charges. So the court will tell you now they will be granting those, and I'm going to take into consideration the other one.
Thank you.
All right. Thank you, sir. You're welcome.
Thank you, Your Honor. I'll explain
You're
it to
welcome.
him.
Thank you, sir. Appreciate it. All right, Mr. Ashmore has just logged in. Do we have his clients up there? Deputy Everett?
Yes, so they're all here.
All right, let me see who he wants to call first. All right, Mr. Ashmore, are you ready on your clients?
Yes, Judge. Thank you so much.
Who are you ready to call first?
Judge, the quickest one would be Mr. Casey Spriggs. We have a discovery check back.
All right,
And
Mr. Spriggs, Mr. Spriggs, come on up. This is CR 21371, State versus Casey Lynn Spriggs. Show that we're set for status on cell phone discovery. Go ahead, Mr. Ashmore.
Judge, Mr. Spriggs has a discovery request that, as we understand it, there were 3 of his, sorry, I'm doing this in the hallway. And one, let me say thank you to everybody for allowing me to appear by Zoom today. Trying to chase down the serial numbers of these phones. This is a couple of years ago now. I just don't have any way to really do that without contacting one of the state potential material witnesses. So as I understand it, there is a receipt. That's the court staff probably laughing at me, Judge, not people eating popcorn in the back. But as I understand it, there is a chain of custody receipt that was provided when these were turned over. I I think that would have the serial number, identification number of these phones, but Mr. Spriggs and I have visited about them, and he doesn't have any way to call that or get access to any of his books and records that would help that. So maybe they don't exist. I know Mr. Woodwike has reached out to the jail evidence, the sheriff's office evidence staff. I have to informally, and I don't know really where that leaves us, except we do think that there is some important evidence regarding potential mitigation on those phones. And if they exist, we respectfully request another opportunity to find them or not. But our request is, I know Tyler or Mr. Woodwike has looked. We've done what we can to find serial numbers. Without contacting a witness of the states, we really can't do that. And if I could put that ball back in the state's court, that'd be my respectful request.
Go ahead.
Mr. Ashmore, I'm unaware who I would be I mean, I'm not at all opposed to doing so. I just don't know who I would be contacting in order to do this.
I think the father. I think Casey's dad.
Okay, and do you know what?
Be my guess, or mom.
Okay, would you
It'd
send
be
me?
one of them two, and I will email that to you.
I would appreciate that, so we don't put on the public all who these people are. So if you would send me an email, I'd be happy to look into it. I'm at a loss as to how I can look further with. I don't know what really I'm looking for.
Yes, sir. I'll get that done.
Well, let me ask some clarifying questions just from my position. So what the defendant is seeking is evidence that's in the state's custody. Yes or no?
Yes.
And the defendant knows exactly what phone he is looking for. Yes or no?
It's 3 phones.
Okay, so the defendant is seeking 3 phones that's in the state's custody.
We believe they are in the state's custody. We don't know for sure, and it's not on any inventory or log.
Okay, that's what I thought you said. I thought you said that there was a receipt, that there was a some type of paperwork whenever they were taken.
Yes, Judge, that's my understanding. Without violating a client confidence, that is my understanding, that these phones were surrendered as part of that initial investigation, which we understand occurred in a different county as well. So it may not be the sheriff's office in custody of these phones, but we don't have that receipt, and we don't have any documentation of that receipt. This is just our understanding.
Okay, and Mr. Woodwike, does anything exist in the state's discovery, to your knowledge, that identifies the seizing of cell phones and any identifiers that go with them?
Make sure. No, Your Honor, we have no information that any phones were turned over to the state that we could turn over. Otherwise, we would have already done so. We have no records of these phones. I can't say that they never were. I have no records of them.
And you've received all of the discovery that was conducted in Dallas County? And or is there a case agent in Dallas County that your investigators could speak with to ensure whether or not all evidence in the state inside Dallas County has been turned over to the state inside Van Zandt County?
I have very limited information of any investigation that occurred in Dallas County. So we can look further into that. It was my understanding from my discussions with defense that this had been turned over to the Van Zandt County Sheriff's Office. Maybe that is incorrect, and maybe that's where we're running into issues. But my understanding is that Dallas County almost immediately turned over this investigation to the Van Zandt County Sheriff's Department.
So, Mr. Ashmore, you're not asserting that the Van Zandt County Sheriff's Office has seized phones, issued some type of tracking control document?
No. I think these were voluntarily given by family members when the investigation was going on, and at which stage, I don't know, because Mr. Woodwike is correct. There are 2 parts of this investigation, one of which was in Dallas County, Texas, and one of which was in Van Zandt County, Texas. I don't know when the witnesses were interviewed, what they turned over or didn't. I know there was some voluntary turnover of property of Mr. Spriggs's example, his car and other things, which we believe include these phones.
All right,
So it
and
wasn't a seizure, as I understand. I didn't mean to interrupt you.
it's okay. And Mr. Woodwike, have you also consulted the discovery in Miss Spriggs' case? I understand Miss Spriggs' case has been dismissed, but have you consulted the discovery there to see if there's any information that Mr. Ashmore wouldn't have, that the state would have, to determine whether or not there's any evidence of phones being seized and or analyzed?
I have looked in Miss Spriggs's case, this defendant's mother, and there is no information as to phones being turned over there either.
So my understanding is after today, court's going to grant another hearing, another reset date, and the two of y'all are going to speak, or one of you is going to speak with Mr. Spriggs' family members. And I'm assuming that's who you're asserting has turned over their phones, or whose phones were taken and analyzed. And that's going to be his mother, father, who's the third person, so that we can get some kind of definitive answer on this and narrowing the scope of what we're looking for.
No, that's it. It's those, we believe it's those two people.
Those two people.
One of
three
those,
phones?
there's an additional witness, and I don't have any way to get my file in front of me. And his name's not on the tip of my tongue, but it's my understanding that one of the state's witnesses, mom or dad is my best guess, voluntarily surrendered and complied with a lot of investigatory efforts, including turning over 3 cell phones.
And those 3 phones you believe belong to 2 people, his mother and father.
I believe they belong to Mr. Spriggs.
So Mr. Spriggs
That's
has
my understanding.
3 phones that the mother or the father turned over for investigation is what the assertion is. Okay.
Yes.
All right. And Mr. Woodwike, you're gonna determine that by contacting Mr. and Miss Spriggs.
I will reach out to, I will have my office reach out to Miss Spriggs and Mr. Spriggs, this defendant's mother, and I believe stepfather or father. I'm unaware of their exact relation. That doesn't really matter. I will note that we do have a consensus search from Miss Spriggs for Mr. Spriggs's vehicle, but it mentions nothing about any cell phones. But I will reach in and investigate further and see what I can find. Beyond that, I'm kind of at a loss as to these cell phones.
Okay. All right. We're gonna set another hearing for Mr. Spriggs, status on cell phone discovery, and this really needs to be the last one. Either we have it or we don't. And we'll set this. Are you available on March 28th, Mr. Ashmore?
I'm set for a final trial that day, which is a special set. Could be
Well, let's just set it that day. Let's set it that day. And if you're unavailable, then there should be some kind of update for the court from Mr. Woodwike that maybe y'all could, send the court something.
Yes, sir.
Y'all can send something to the court in writing. We can put it on the record on the 28th for Mr. Spriggs' benefit. And then if we have the phones there that day, great. Then all I'm going to do is set it for a pretrial hearing after that.
Yes, Judge.
Okay.
Yes, Judge.
All right. Thank you, Mr. Spriggs. We'll see you back on March 28th. All right. Donnell Shelton, CR 2247, CR 2248. All right, Mr. Ashmore, I believe that these are set for motions to withdraw. Is that correct?
Yes, Judge. We've kind of had this request from the defendant before. We have. That being said, after the hearing to terminate me as court-appointed counsel, which was denied, I was informed by the state bar that a formal grievance had been filed, and I've done some research on that, and I believe the state bar rules do require me to bring that conflict of it. It does create a conflict and sours even more the relationship between the indigent client and the appointed attorney. So I filed these out of an abundance of caution. Those state bar complaints have been resolved. and dismissed. That being said, this was filed at that time.
You go check.
So the purpose of this is to comply with the state bar rules and give deference to the court with however the court decides to handle this. But it does technically raise a conflict because there's an adversarial position between the attorney and the client with regards to that bar complaint. Even though that's been resolved now, again, giving deference to the court, raising that as I understand I'm required to do.
All right, Mr. Shelton, just for purposes of this hearing, the motion to withdraw. You do not oppose Mr. Ashmore withdrawing as your attorney, correct?
Yeah, yeah, he can oppose to it, but I just wish he.
You got to speak up. I can't hear what you're saying.
I said, I said, I wish he would drop off my case.
Okay, and if he drops off your case, how long are you going to sit there until you have another lawyer? When are you going to hire an attorney?
Well, I can't hire an attorney being in here. If I was out in the world, I hire an attorney.
So you don't have an attorney because you told me you can't afford one. I appoint you an attorney, and then you file a grievance on him and create an adversarial position between you and Mr. Ashmore. What's to make me believe that you're not going to do that to the next attorney I have? And I only have very few attorneys that are willing to represent people like yourself who are indigent and taking court appointments. I only have very limited attorneys that do that. What am I supposed to do?
Well, I understand that, but I just want a lawyer who believe in me.
I can't hear you. You want him to do what?
I said, I just want a lawyer who believe in me. Trust what I'm saying. I don't need a lawyer that's going to be against me. Like I say, you don't never, contact me or talk to me. Last time we was here, when we talked in the room, he told me that she will come down to a certain number, and I have to December, no later than January, to decide. I never heard from him about that issue.
Do you have any family or friends that are willing to help you hire an attorney?
No, my little brother, my mom, she live off her disability. My older brother, he had 4 kids, I'm taking care of his family.
All right, court's going to grant your motion to withdraw, Mr. Ashmore. If I were you, I wouldn't want to be fighting the state for Mr. Shelton and then turn around and fighting Mr. Shelton when you're not fighting the state. So I know that's got to be very complicated to fight for your client when your client's fighting against you. So I'm going to go ahead and grant your motion to withdraw in this case. And then Mr. Shelton, I'm going to have to go see if I have any other attorneys that are willing to take this case. So I'll be in touch sometime. Don't know when that's going to be.
Okay, I appreciate it.
All right. Have a good day.
Judge,
Good.
well, the judge here is calling me back. I don't want to expedite. It's an identical situation. And I don't want to deprive Mr. Reyes of whatever he needs to say to the court, but I'm getting the hook over.
Did Mr. Reyes file a formal grievance as well?
He did. It was summarily dismissed, but it creates the same conflict.
Okay. All right. I'm going to grant your motion to withdraw from Mr. Reyes. I'll allow him to say what he wants to say. You're free to go.
Okay, Judge, I apologize. And
problem.
thank you so much.
You're welcome. Mr. Reyes, if you'll step up, CR 22-114. All right, Mr. Reyes, Mr. Ashmore has granted a motion to withdraw as counsel. The court's granted that. Are you going to hire an attorney?
Yes, sir.
All right, go have a seat and I'll try to find if there's someone available. I don't know that there is, so I'm not sure how long you're going to sit there. I'll be in touch sometime.
Judge, I had filled out resets for Shelton, Spriggs, and Reyes. You want me to fill those out?
Yes, on Spriggs, you can set that for March 28th. Status of cell phone discovery. Shelton and Reyes, no, because I'm not sure when their next hearing is going to be. I'm not even sure I can get them a lawyer. So no lawyer, no hearing. I don't know how long they're going to be able to sit there. And nothing's going to be going on their cases. So.
On Spriggs.
Say again. Yes, so we really don't need that hearing on that though, do we? All right, for the record, cause number CR 2182, State versus Alex Chad Manis. The court has received notification from the facility in Montgomery County that they are requesting a bench warrant be issued from the court for us to retake custody of Mr. Manis. I believe that report's been provided to the state and the defense. So the court's issued the bench warrant so that he's not released. And we'll schedule him for a hearing once he gets back in our custody. And then we'll need to address with Mr. Ashmore the report that Montgomery County is giving.
Continued in incapacity. Yes, Judge. I will speak with Mr. Ashmore and see if we can't figure something out. Our hands are going to be pretty tightly tied on this, but we'll do what we can.
Okay. So once he gets in our custody, then Ms. Taberham will set him for a hearing, and because I'm not sure when that's going to be, when we're going to get him and what docket would probably the 28th, I'm guessing, is the next available, but you heard Mr. Ashmore say that he's probably not going to be available on that day. So we'll just wait and see. Ms. Taberham will give us a date.
I appreciate that.
So, Mr. Williams, if you're in the courtroom, if you'll come up, Leonard Williams, CR 2372. From what? Okay. All right, Mr. Williams, today is a status hearing on your hiring an attorney to represent you. Do you have any updates for the court?
Yes, we've been trying to wait on Mr. Weiner because I signed a paper about for him to I guess reverse our money back because I guess they finished paying it, but we've been talking to the judge demanding to take over the case, so that's how we're waiting on. The paperwork up here, and my family been trying to get into adjusting, but he hasn't returned a call or anything. The paperwork up there for him, fax over to him, so it's been sitting there.
So do you want me to give you another reset so that you have time to get that done?
Yes, sir. Please, if you could.
I can do it. My only concern, Mr. Williams, though, is the longer you sit there, the longer you sit there. There's nothing going on in your case. Nobody's going to be working on your case because you don't have a lawyer. So I'm going to give you until March 28th. And
If
then
it ain't done by the 1st of March, I'll fill out for indigent. I'll fill out for indigent court appointed attorney.
all right, court's going to set Mr. Williams in for a status on attorney. That'll be March 28th at 1:30.
Yes, sir. Thank you, Mr. Moore.
You're welcome. All right, I guess on dusty roads, I don't see Mr. Weiner, but I guess on dusty roads, let's just reset him. He's not in Henderson County custody or ours. I believe he's at the Beto unit, you said? Beto unit. We're showing he's in custody in the Beto unit. And he received 2 years out of Henderson County? Okay, so if the state is wanting to continue their prosecution of Mr. Rhodes, then is there a request for a bench warrant?
Yes, Your Honor. And we would continue prosecution. If we could if we could reset it basically a month for status regarding custody, if I can speak with Mr. Weiner, I'd rather not bring him back just so we could have him in our custody while he's serving TDC time while Mr. Weiner and I are discussing. So if we could have a month so I can hopefully speak with Mr. Weiner, try to reach some sort of resolution. If not, basically set it, bring him back, work through the process, and then whether we have him wait for trial here or there will be a discussion for them. But I'd rather not start that process of him sitting here just while we're trying to work through it.
Absolutely. I think that's a fair request, and I think that's the best move. So the court will set Mr. Rhodes for status on custody March 28th. And then we won't issue a bench warrant between now and then. I'll give you time to work with Mr. Weiner. If I can work it out, great. If you can't, if you know that you can't even before the 28th, then just go ahead and send your bench warrant request over to Ms. Taberham. We'll issue it. Maybe we can get him here about the 28th.
That works for me, Your Honor.
All right, great. Appreciate that, Mr. Woodwike. And I'm looking through my docket. I believe that is all. Yes, Shelton. All right, if there's nothing else, then appreciate everyone's help at the jail, and we'll be adjourned for the afternoon docket.
Thank you, Your Honor.
You're welcome. You have a good day.